As you are entering this seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually, and unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's April 24th, 2026 free CLE webinar, The Evolution of Technology for Florida Clerks of Court. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. The chat feature is disabled. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. We are not taking attendance. I will now turn it over to the FRP Enrichment Committee CLE Subcommittee member, Bonita Smith.
Thank you. The Florida Registered Paralegal Enrichment Committee invites all of our participants today to visit the FRP Corner on the Florida Bar website, as well as our various social media platforms. It is there you will find helpful tips and announcements of upcoming events in our monthly webinars. Roberta Walton Johnson is the General Counsel and Legislative Affairs Director for the Orange County Clerk of Circuit and County Courts. Roberta joined the Clerk's office in 2015, where she launched and led the Lydia Gardner Self-Help Center, an initiative that has expanded access to justice for thousands of self-represented citizens. Roberta is a proud graduate of Florida A&M University, earning her bachelor's degree in 1996, and later her Juris Doctorate in 2005 as a member of the inaugural class of the reestablished Florida A&M College of Law. Her career has spanned roles with Community Legal Services of Mid-Florida, Orange County Government, Voight, PA, and leadership positions within nonprofit organizations across the Big Bend region. Her commitment to public service extends far beyond her legal work. Roberta serves as Vice Chair of the Florida A&M College of Law's Dean Advisory Council and contributes to several influential committees, including those with the Florida Bar, Orange County Government, and the Florida Office of State Courts. She is also an active member of multiple bar and professional associations throughout Central Florida. In addition to her professional accomplishments, Roberta is a leader in the nonprofit community, serving on the boards of the African American Chamber of Commerce of Central Florida, the Epilepsy Association, and the Community Foundation of Southwest Orlando. She is a dedicated member of Alpha Kappa Alpha Sorority Incorporated with more than 25 years of service and currently serves on the South Atlantic Region Cabinet as General Counsel and Chair of the Conflict Resolution Committee. Above all, Roberta finds her greatest joy in her family. She is married to Neil Johnson and is the proud mother of two sons, Dakari and Dylan.
Well, thank you, Benita. I think that's my cue, right? It's very difficult listening to yourself be introduced. All right, I'm going to go ahead and get started. So thank you all so much for having me. Benita kind of shared a little bit of my background, but I will tell you, I consider it an honor and a privilege to present to you today to share just a little bit about the evolution of court records here in the state of Florida and how that has impacted Florida clerks of court across the state, which again, that kind of transitions down to you all, our number one customers. Okay, all right. So just let me start with first the overview. Florida Clerks of Court, as you know, we serve as constitutional officers. And when I say we, I am on behalf of my clerk here, who is an elected official, but they're constitutional officers. However, their duties are largely ministerial in nature. And what that means is they really only carry out the functions as prescribed by law. They don't have any judicial discretion when making decisions about court filings, and how something should be enforced from a substantive perspective. It's all procedural here. And that procedure is really guided by statutes, court rules, directives from the Florida Supreme Court, and primarily the Florida Rules of General Practice and Judicial Administration. So while court clerks do receive guidance from Florida statute, when it comes to the court side and judicial procedure, that is coming from the Florida Supreme Court, which in large part is highlighted in the Florida Rules of General Practice and Judicial Administration. The clerk's authority is not administrative alone. It really is constitutionally grounded because we are mentioned in the Florida Constitution, and that's where our powers stem from. So when you talk about the procedural power and the functionality of your clerk of courts, it is ministerially aligned. You can always find it somewhere in the law or court rule. So as we phase into the evolution of where we are technologically, because some of you on the line may recall that, there was an era where we were paper, but now we consider ourselves digital officers. Florida operates a hybrid model when it comes to judicial filings. There is one statewide e-filing system combined with 67 different local case management systems. So when I say hybrid, yes, there's one statewide e-filing system, but many of your clerks across the state all operate a unique case management system that really is unique to their area and the customers that they serve within that county. There is no single uniform case management system across the 67 Florida clerks of court. And I think that's very, very important, especially for this audience, because oftentimes operating from county to county, it is not seamless because of the local CMS systems. So when we start talking about how we have evolved, it came about because of that statewide integration. So I talked about the fact that our case management systems across all 67 counties are decentralized, and so are those technology platforms, and so are those local procedural workflows, meaning how clerk offices operate, how they work procedurally can and probably is different from county to county. But what is centralized is the e-filing, are the rules and the access controls that really are exclusive across all 67 counties. And here are a few of them that I want to share with you right now as it relates to those tools. The Government and Sunshine Manual. You probably have one sitting on your desk right now. That is an exclusive tool that is used by all 67 counties. When you're talking about access to confidential and exempt records for government agencies. The access security matrix. And I'm not sure if everyone on the line is familiar with this tool. If you are not, I would recommend that you embrace this tool because it is a tool, it's a standardized tool that has been adopted by the Florida Supreme Court, but it is our number one go-to when someone is asking to access certain records. Court records are categorized into public records, confidential records, and those records that have exempt information within them. And they're categorized by user on who should have access. And all of that is embedded within the Florida e-filing portal and all 67 local CMS systems. So that is the reason why this tool is extremely important as it relates to online access. It's also covered in the Florida court rules. Florida court rules, as you know, are also a go-to and exclusive for procedurally the direction that the clerks have when it comes to processing documents, when it comes to exactly how we are supposed to handle different procedural matters. Three additional tools, Florida Courts e-filing authority, which is the governing agency for the Florida Courts e-filing portal, excuse me, the statewide e-filing portal. There is a agency, a board that consists of clerks, right? But it is the authority that oversees the e-filing portal. And so it really is a collective entity of all of a group of constitutional officers across the state that have been appointed to this board to serve to make sure it is governed accordingly. Another one is the CCIS, which is the Clerks of Courts Information System. This is sometimes confused with its function between the portal versus the CCIS, because this really is the statewide repository for data and court case information. So while cases are filed within the portal, they are held in CCIS for data purposes, right? For to look at statewide reporting and analysis. This is closed to the public. It is not open to the public, whereas the portal is. So the two kind of work hand in hand and kind of feed off of each other. Both are governed by clerks. Lastly, the distribution schedule of court-related filing fees, service charges, costs, and fines. If you don't have this, I would recommend you also, and you will have a copy of this presentation, go to the link so that you can access these particular files, because I think they're important. This really is a breakdown of how fees are distributed throughout the state once we receive them. As you know, clerks, we really are the cash register, I always call us, right? We are the cash handling side also for the courts. And so when funds are distributed to the clerk, it is our responsibility to make sure that they are redistributed to the different trust funds and the different agencies that are supposed to receive those funds. All of it is tiered off into a percentage, and that is outlined in the distribution schedule as it relates to filing fees, service charges, costs, and fines. So if ever there is a question about where the funds are going, if ever there is a question about how much you are going to be assessed when it comes to filing fees, that chart will provide you with that guidance. So as we are flowing into the evolution of technology, I think it's important to share that, again, it's all ministerial, and I've redirected you to the real purpose of how we got here and how it is outlined in the rules and in statute accordingly. The whole purpose for transitioning our court system from paper to a more digital platform is to provide statewide uniformity and standardization throughout the state. That is so important. And that is what the rules are attempting to do when it comes to the portal and all of the standards, the standardized filing criteria that has been produced by the courts. so that we can see a little bit more uniformity and standardization throughout the state when it comes to court filings and procedurally how that operates. The other part is an increased public access to increase public access and transparency. As we know, we are operating in the spirit of sunshine here in the state of Florida, right? And so transparency is incredibly important. So important, it's outlined in the Florida Constitution, as you can see right here, redirecting where you might be able to find the rules and the state law that guides this effort that the court is making sure it enforces through our court filing system. Also, enhanced efficiency and timeliness. There was a time where you had to get in the car and drive to the courthouse, right? If you wanted to see a file. Now, because everything is online, that has shifted tremendously. And that has shifted across all 67 counties where there is an opportunity for every county to adopt some type of digital platform. Now, of course, some are going to be a little bit more modernized than the other, depending on the size of the county. But for efficiency purposes, you're going to continue to see this evolve from county to county. Let's see. Lastly, it's the stronger data security and confidentiality protections. We are living in a time where cybersecurity is becoming a more enhanced priority within our state courts more than ever before. Why? Because we've seen how important it is to safeguard some of the information that we hold here within the courts on behalf, within the clerk's office on behalf of the courts, that is supposed to be information that, again, considered confidential and exempt. And for all the reasons that we know, this information, if shared, right, and if made open to the public, can be harmful to many. And so for that reason, we're seeing stronger protections. We have 25 exemptions, as we know, under Rule 2.420 that we live by here with the Clerk of Court's office. But then we also have Chapter 119, which also governs public records. And so because we are dual, we are a government agency, but we're also a part of the judicial branch. These two rules are our guiding principles when it comes to confidentiality. Now, just kind of an overview of this transformation. It really did occur from a phased approach. And so here are the 4 phases of the evolution of how we have evolved from paper to digital. And phase 1 is the digitization of records. The transition from paper to electronic document storage and the scanning and indexing of legacy case files has been adopted across the state. There are some clerk's offices that are still scanning these legacy case files, but for the most part, I believe we are almost there with all 67 counties. Now, with the digitization, that does not mean we don't have certain documents, and clerk's offices are not mandated to still keep certain paper documents for a certain time period according to the Florida retention schedule. So when it comes to retention schedule of court records, which is outlined in the Florida Rules of General Practice and Judicial Administration, and the retention schedule that's outlined in the GS-11 for public records, please note that there are some documents that we are still mandated to keep for a period. However, once it is scanned and indexed, that is considered, the electronic record is considered the official record. Phase 2 became the statewide e-filing implementation, which was the launch of the Florida Courts e-filing portal and the mandatory status for all attorneys to e-file. What you are seeing unfold right now is a more standardized filing system in terms of codes and how files are being docketed into court record. That is a pilot project that is happening throughout the state right now. And while you are still seeing certain docket codes differ from county to county, we are transitioning into a more standardized docket coding system. So that is more or less where we're going under the second phase. Phase 3, an integrated case management system. Right now, what you're seeing is seamless integration between e-filing and the individual clerk CMS systems across the state. As I stated earlier, there is not a unique local CMS system across that every county or all counties have adopted. They differ from county to county. But there are real-time docketing and case updates, and those, quite frankly, happen because of the integration between our e-portal and those local CMS systems. The last phase is going to be phase 4, which is compliance, confidentiality, and governance. What this really is we now have these more enhanced protocols for confidential information and redaction. And so, as you've seen in the last few years, especially if you're operating on the civil side, about the notice of confidential the notice of a confidential filing, and the fact that that is now required from the filer, not so much as the clerk has to be on the lookout for that. So that's extremely important for the civil filers. Those you have to file that notification because the clerk is not going to bear the responsibility. The onus is on the filer to make sure that information is there, and then the clerk will process it accordingly. So what that does is it provides that additional clarification of what the clerk responsibilities are in reviewing the filings versus what the filers are. Now, the impact of all of that on clerk operations, quite frankly, is what we're seeing is that clerks are responsible for ensuring procedural compliance, but not legal sufficiency. And I think that is extremely important. Clerks should not be going through filings looking to see if they are legally sufficient. That is the responsibility of the courts and not the clerk. Also, it is the clerk's responsibility to review for accuracy and integrity of the filings. And that is based on the standards that have been adopted by the Florida Supreme Court. It's also the clerk's responsibility to make sure there are proper classifications and the indexing of records, meaning docketing. That is our responsibility. And also it is our responsibility to protect and safeguard confidential and sensitive information. Keep in mind, however, if you are a civil filer, it is your responsibility to make sure that you have filed that proper notice to alert the clerks to look for that information, because that is not our responsibility. In essence, the overall impact is clerks now serve not only as record custodians, but also as technology administrators overseeing a digital intake system. So what I wanted to really share with you, that was kind of a high-level overview as to where we started, why we're here, how we got here, the purpose behind it all. And now I would like to share with you our e-everything package, right? E-everything happened to us in 2025. And this presentation is going to continue to outline the transformation of technology within our judicial system, as guided by the Florida Rules of General Practice and Judicial Administration and reinforced by the Florida Supreme Court case SC 2023, which is a 1401, excuse me, which is a 2025 opinion of the Florida Supreme Court that really did an entire overhaul on Florida's electronic filing framework. Okay. Hopefully everyone is familiar with this opinion because it really has overhauled how clerks are going to impose their new role as the digital case intaker. Okay. E-everything effectively codifies our e-filing environment into the core Florida court rules as follows. It makes the portal the default for filing and for service. It clarifies who must and may e-file and how signature certification rules apply in the electronic context. It tightens and standardizes clerk authority to reject or queue filings. We're going to come back to that one in just a minute. It aligns document formatting and authenticity requirements with the Florida court's technology standards. And it sets statewide baseline expectations for electronic filing and clerk practices, aiming to improve uniformity, arbitrary rejections, and to ensure that the official court file is reliable. So let's go through the breakdown of those those rules that this opinion amended. The first one is electronic signature of court officials. Basically, this opinion now says that it documents in the official court file that if we have a filing that is signed by a judge or a court official, it is presumed authentic. Okay? Any court filing signed by a judge or court official and made a part of the official court record is presumed authentic. The next one, Rule 2.511, formally defines the statewide portal as the central filing facility for all Florida courts and outlines those credential requirements for registered users, and makes the portal e-service mandatory when filing through it. That major portion is if you are filing through the portal, e-service is mandatory and mandatory through the portal. That means if you intend to serve someone and you don't have them listed in the portal for purposes of e-service, that should be updated because it's mandatory if you're filing this document through the portal for you to also e-service through the portal. Rule 2.515, it revises the signature block requirements and explicitly states what representations a filer makes by filing a document. Rule 2.516, when it comes to service, it retitled and amended this rule to require that documents filed through the portal, again, we talked about that one already, Yeah, okay. Talked about the e-service already. Okay, next. Documents that are served but not filed must be served by email when a PDF attachment with a carve-out allowing certain unrepresented in custody parties or signers to file that 2.601 stating that they don't have an email address. So this is giving that out for those prosayers who are saying, you know what, I don't have an email address for you to e-file me in the portal. And so this is providing some instructions and directions on how to continue service when it comes to those prosayers who don't have that email address. Rule 2.520, that rule is basically amended when it comes to formatting requirements as it relates to margins, fonts, and requires that electronic documents comply with those updated Florida court technology standards. It includes, as it relates to exhibits not created for filing, like photos, business records, are not subject to the same strict formatting as those other documents, those ones that are considered for filing. So exhibits not created for filing are not subject to the same strict standards, but if they are created for filing and are trying to be made a part of the official record, yes, they should also be formatted accordingly. Rule 2.525, when it comes to electronic filing, it allows unrepresented parties to elect electronic filing, but makes that election binding absent a leave of court, i.e., now with pro se litigants, once they elect to and receive and elect to receive an electronic filing, it is binding on them now. It also defines the official court file as the set of electronic documents maintained by the clerk. There are some limited paper exceptions, as I discussed with you earlier, that by statute we still must keep via paper. However, for the most part, the electronic record is the official court file. It also directs clerks to make submitted documents part of the official file and to index them in the progress docket, unless there is a defect with that filing. And if there is a defect, that filing must be redirected to the correction queue. So when the clerk's office, when you hit submit and we receive that filing, this rule is directing us to accept it and make it a part of the official file. Why is that so important? Because oftentimes we receive emails, it was an accident, I apologize, I didn't mean to hit send, there is a Scribner's error, there is some type of error that I made, or I would like for it to be rejected so that I can send over the document I intended to send. That we can no longer accept. That is no longer a reason, quite frankly, unless it falls within 7 distinct reasons of why we can reject a filing. Now we must accept that filing into the official record. So when standardizing, and this is key, this piece of this opinion really did standardize when clerks can and how clerks can reject filings and place them in the correction queue. Under Rule 2.525, filings go into the correction queue only for a limited reason. missing or incorrect case numbers that cannot be reliable or identified by the clerk's office, missing or incorrect case style, multiple documents improperly combined or one multi-page document split into several filings, proposed orders filed improperly, illegible, corrupt, or blank documents, or documents barred by court order or incompatible with the case management system, meaning we can't do it because our system won't allow us to do it. If we receive an order like a vexatious litigant order by the court, that bars us from accepting. But if it's not one of those reasons, we have to accept the filing. And then you have to deal with the court again, because we don't do legal sufficiency, right? You have to deal with the court on how to have that document struck from the record. So in essence, the clerk holds, if it goes to a correction queue, the clerk will hold the filing in the queue for 30 days after notifying the filer about one of these reasons again that we've rejected the filing. If we do not hear from you within that 30-day period to correct the filing, then it is deemed abandoned. Keep in mind, the filer may submit a corrected document that relates back to the date of the unsuccessful filing in order to move the review for the clerk's action to docket it into the official record. But again, if we do not hear back, it goes into an abandoned filing. After those 30 days and it is inserted into an abandoned filing, the clerk's office does not have, we don't have a way to access it. It goes away. And then from a timestamp perspective, you really do have to start all over again. What this does, this opinion is really, in essence, narrowed clerk discretion across the state. Because before this opinion came about, different clerks' offices rejected different filings for a myriad of reasons, hundreds of different reasons. And they would free text what the rejection reason was and share with you, we've rejected it for XYZ. So this is narrowed that window of clerk discretion of how and when we can accept a court filing substantially. So because of that, I just want to go through a quick checklist with each of you of before you hit file, the importance, because that discretion is no longer with us, the importance of what you should look at on the four corners of any filing before you hit send. The first is case information. It is extremely important to make sure that you have the correct case number, the correct county, we see that a lot, and court division. And also that the party names match exactly as styled in the case. Document format. This is extremely important, and document format can be found in the Florida Supreme Court standards of electronic filings, but PDF format only. The document is legible and properly oriented. The file is not password protected. In this new era of cybersecurity, a lot of times when we get documents, if it is corrupt or there is a password prompt on it, there's nothing we can do with that. That's going to fall into that. It doesn't, our system won't allow us to take it. And separate documents are uploaded as separate files. If you intend to file a motion and you are attaching documents to it, um, according to the standards, those files should be separated and referenced accordingly. Filing codes and fields. Correct the filing code selected. A lot of times when you are selecting the case type, when you go into the portal, it does not always align with what your intent is. So when it is docketed and processed on our end, we're going to process it according to whatever you selected. So that means that all required fields should be completed accurately. Signature. Um, Make sure the proper signature is included. Um, Sometimes there is going to be an electronic signature imputed. For legal, and again, this is outside the scope of the clerk's office, but I still share with you, it is important that if an electronic signature is not allowed, um, then you should make sure you have the proper signature when filing. The filing fee. The filing fee, and I'm going to also say surcharges to make sure that these fees are paid appropriately and processed successfully. A lot of times we will get proposed summons or there's questions about, I don't understand, I haven't received the writ yet, but the fee is also not been submitted. So I think it's extremely important to make sure that that is done as well. Also, in large part, you have sometimes where you're filing a certain case type and you've captioned it a county court case, um, but it the fee is not correct because you're dealing with a different amount, so it's outside the scope. So making sure that all of that aligns. Rule compliance, the proper caption and case style is included, and all required attachments and exhibits are also included. Confidential information, we talked about that notice of confidential information being filed. And if there is sensitive data included, making sure that that is redacted and truncated accordingly based on the rules. And then finally, there is no duplicate or incorrect filings. Believe it or not, that happens a lot. And also that materials are submitted to the correct case. And I will even say to you, once you have filed, go back and check your filings in a few days to make sure that everything is aligned as you intended. And if not, please feel free to reach out to your respective clerk's office for additional support as it relates to your filings. So this covers my overview about technology and how we are now engaged into the e-everything world based upon the Supreme Court opinion 2023-1401. If you don't have a copy of that or in your respective offices, I would also say that is something that you and the attorneys that you represent should become one with, because that particular opinion took several years uh, to give birth to, and it did amend quite a few of the rules of general practice and judicial administration to get us here, but all dealing with how we have evolved from paper to an official electronic record, and who has the discretion to do what and whose role it is to do what. as it relates to filing court documents. So I have questions on the screen, but I see that there are 11 questions. So if you have questions, I'm going to attempt to answer as many as I possibly can. Why can't there be a uniform system of the clerks in all 67 counties? That is a great question. Right now, the reason and the rationale is because all 67 counties don't look alike in terms of size, in terms of resources, and because of the funding model and how clerks are funded. Right now, they have not gotten aligned in terms of how it would be practical to outsource a case management system that could truly support the needs for all 67 counties, including our larger counties and then some of our smaller counties, because the needs kind of look different depending on where you are, where you sit in terms of size and in terms of budget. Hopefully that makes sense. The second question, in family law, asset and other information is public to a large degree. I've had clients come to me after having outside parties pull their information. Is something going to be done about more protection for personal information? So as it relates to personal information, and I'm sure we are all aware online, there are quite a few exemptions in Chapter 119 and in Rule 2.420. But as it relates to, judicial records in Rule 2.420 right now, your social security number, your credit card numbers, your bank account information, all of that information right now is deemed confidential. Your name is not confidential. And in large part, your address is not confidential, depending on your status. Because if you do fall in one of those classes, I myself fall in one of those classes because I used to be a manager for a child support division. And so that falls into one of those exemptions under Chapter 119, of which my address and is confidential. Even that, my name is still not confidential. That is still open for the public to see. Because we operate in the spirit of transparency and we are supposed to opine on to along to the side of open and open access and to be more transparent as a government agency, that is the direction that our Florida Constitution kind of guides us into and pushes us towards. So that's the reason why many of the rules are heavily scrutinized as they are aligned up against the Florida Constitution. So right now, that's really where we sit. Yes, that information is still public to date, unless they fall into another class. And so I would encourage you to go into Chapter 119, become one with that as you are sitting with clients to help them if they may fall in one of the classes and don't even realize it. Because many of the classes also include children of individuals. That fall in these categories, and you never know. Has there been, or lastly, I just want to go back to Anonymous about the family law asset information. The other part is if you feel strongly that the information should be held, should be made private and not disclosed to the general public for other reasons, you can always file a motion and request that the court find that the information be made confidential. And so that is all already a procedural process that is outlined in the rules of general practice and judicial administration. Has there been or will there be any discussion about uniform naming of digital filings and docket indexing across jurisdictions similar to the federal courts? Yes, there is. There is a pilot project happening right now. And I believe that pilot project is happening in Sarasota County. So if you are located in Sarasota County, you are already experiencing a few of the proposed uniform docket indexing of certain motions and certain filings right now. That pilot project I know has been in play either 1 or 2 years. And so it is still a subcommittee that is meeting and addressing that. And it is um, a cumulative subcommittee of clerks, of state court administrators, and other practitioners that are involved with that procedural process to kind of help us adopt a more uniform indexing across the state. So that is underway. We're not there yet, but it is underway. Happened to me, filed in the wrong county. It happens to a lot of people. And unfortunately, your clerks probably told you there was nothing they could do about it. That is the reason why we just went through that checklist and why it is ever so more important today, now that the adoption of this new e-everything opinion is in effect and has been enacted, so that everyone understands that it's not that your clerk of court is being difficult. We just have some different discretionary rules that we are under at this point. What is an example of something that would be incompatible with the case management system? I think I gave an example earlier when we talked about a password protected document. Would be incompatible because we could not otherwise even accept that into our system. You would have to remove that from the document altogether for us to be able to accept it. So that can give you an example of something that's incompatible, because conceivably we would not even be able to process that. Filing was accepted, huge learning lesson. Got it. Perfect. Can the clerk reject a new filing if it was filed in the wrong county? The style says a different county than the county you accidentally filed it in. So, you said, can the clerk reject a new filing if it was filed in the wrong county? So again, we go back to those 7 reasons of why the clerk can now, because our discretion is now limited, it is filed after a case number is assigned and lacks a correct case number, and the case number cannot be relied upon because we can't identify where this case number came from. That's the reason. It lacks a case style or has the wrong case number again. Lacks a case style. It consists of multiple documents filed as one, or consists of a multi-page document filed as separate documents. Is a proposed order unless it is filed under a notice of filing for purposes of preserving a record. Is illegal, corrupt, is illegible, corrupt, or blank. Not illegal. Forgot one of the L's. And is barred by order of the court, or is otherwise incapable of being filed in the clerk's case management system. So to answer your question, just because you put the wrong county, if you have a valid caption there, then, and it's a new filing, no, we cannot reject it. It is going to be processed and given a case number. And the filing fee is going to be assessed. What is a confidential document exhibit to a motion? What if a confidential document exhibit to a motion is accidentally attached? Can it be rejected before it becomes public? No. If it's not barred by order of the court, it's going to be accepted. And I can tell you that happens a lot, especially for my friends from the state attorney's office. Hi, friends. But that happens a lot. And, and we get phone calls, we get yelled at, oh my gosh, you put that out there for the world to see. And keep in mind, no, we did not. When that document comes, if it is intended to be confidential, it should have that notice letting us know it's confidential. If it is on the criminal side intended to be confidential, it should be docketed accordingly so that we realize it's confidential. I know there is a little gap there when you have someone who's working with the criminal agents, the state attorney side, and you have someone who is now going to work with you and is going to testify, and you want to file that information in the record. It needs to be properly docketed so that your clerk's office recognizes that's what that is. There are some clerk's offices that only have a handful of docket identification choices. In one county, you pretty much have to select other for most documents that are not a pleading or a motion. Will this be changing? So that should not be the case. Again, the portal is governed by the e-portal authority. And so while, yes, there is this pilot that's going on with trying to condense and uniformly identify how we docket, there's still certain pleadings across the state that are identified in the local systems. So, but there are some smaller clerk's offices that are just going to say a motion. Whereas there are some, larger circuits like the one that I'm in that will have, more detailed motions. In that instance, even when we don't have a name for a more detailed motion, our clerks in some of our divisions actually write in a note, right, in the case management system, so that the judge is aware, and quite frankly, everyone is aware of what it is. If that is a problem in your individual circuit, I would recommend you bring that to the clerk and to the judiciary's attention, because that you may need an admin order from the local judiciary to help broaden what your options are. For documents where clients are e-signing verified motions or petitions, some platforms, Adobe, save the files as protected to avoid tampering. We are unable to e-file these. What is the workaround? That is a technical question that I would recommend that you talk to your technology team internally, because as you've seen, if it is protected, in large part, our systems won't accept it. That is the reason why you're not able to e-file it, because it's incompatible with our case management systems. And again, keep in mind the portal and the local CSM, there's integration there. And so they work seamlessly together. Once you file it into the portal, we accept it out of the portal and it is integrated into the local CSM. And ultimately from the CSM over to CCIS for data analysis purposes and for reporting to the Office of State Court Administrators. Also, are we required to include the last page, such the audit page or audit trail in e-sign documents acts as a legally admissible tamper-proof record that proves the authenticity of a digital signature, ensures document integrity, and establishes a chain of custody. For purposes of the clerk's office, I'm going to answer that question and say it is not required. If you're asking me for purposes of the courts, I cannot answer that one. If you want to include that as an exhibit to show authenticity of the digital signature, that would be a decision that is unique to you, to your office, to make sure that you're covering yourself. But that is something that is either up to your office or if it is requested or demanded by the courts. But from the clerk's perspective, that's not something I can see that we are going to require. Just to clarify, CCIS is accessible to the clerks and judicial community directly, but not available directly to those of us working on the other side of the court records. You are right. I think I heard that my time was up. I see it's 1 o'clock.
Yes, if you want to go ahead with the last question, then we'll wrap it up. Thank you.
Do the courts provide file stamp copies for e-filings right away, or is there a delay? I'm going to assume that you're talking about, do the clerk's office provide a file stamp copy, meaning the date stamp for those things that are e-filed? It is almost imminent. So yes, once it's e-filed and processed and docketed into our CMS, meaning that we have to accept it into our CMS. So once we accept it, yes, we can provide you with a copy. But if it is still in limbo, let's say it's in a correction queue, or let's say that we have not pulled it into our CMS yet, no, we cannot give you that timestamp. It has to be accepted by your local clerk's office before we can provide that. Can you explain the part of separately filing? Oh, I'm not sure what you're referencing. I think you might be referencing sometimes we have parties who will file a huge packet of documents all together, right? You might file a motion, then a notice of filing with a whole lot of other intended documents. And the way the e-filing standards read is that those things should be separate. Why do the clerks require the original bond instead of the electronic bond with e-signatures? I'm not sure I understand what that question is.
It's okay, Roberta, we're getting some comments that some folks have to jump off for other meetings. So
okay. Yes.
I just want to make
sure.
There's
a lot more questions that I don't think I'm gonna be able to get to, quite frankly, Diana.
That's fine. And if it's okay with you, I'm happy to email those questions to you if you'd like to see them.
Yeah, that's fine. Mm-hmm.
Okay. I will do that for those that didn't have their question answered. I'll go ahead and send that to you. And thank you so much. And thank you all for attending today's webinar. And the course number for today's webinar is 9791. Again, the course number is 9791. This webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general CLE credit and 1 hour of technology credit. Please self-report this course in the member portal. Again, the number is 9791. You will receive an email tomorrow via Zoom outlining this information. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is a completely confidential and free service which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.